like to thank Washington Telugu Association for arranging this call, especially Jaypal Dutta and Srinivas Garu and all the Washington Telugu Association team. Hello, everyone. By the way, my name is Santosh Somireddy. I'm the founder of Somireddy Law Group. We're a full-service law firm with offices in Virginia, New Jersey, India, and in the process of opening an office in NC. My core areas of practice include immigration, litigation, corporate, and employment law. Now and then we do handle other areas of law, including family and criminal, but my more concentration is on immigration and litigation. Before we start, just want to let you know that I'm currently licensed in Virginia, New Jersey. So I handle litigation, corporate employment law matters only in these states. In remaining other states, we handle mostly immigration, but soon I'll be getting licensed in other states like Texas, Illinois, Michigan, Washington. This is in Washington, New York, Pennsylvania, and Georgia and NC. Before we get to the topic, a small disclaimer. Please note that anything that we discuss here today should be construed as a friendly discussion. Hence, I would not recommend that you act upon this information without seeking the assistance of an individual counsel. So basically, whatever we discuss here today should be considered as a friendly advice. And if you have anything specific to your matter, then you need to reach out to a particular counsel who is licensed in that particular state. In that way, you get the proper legal advice. And neither Somireddy Law Group nor Washington Telugu Association assumes any responsibility or liability for any errors or omissions in this content and that we're going to discuss today. And also, this does not create an attorney-client privilege relationship. So, hence, we want you to make an informed judgment before seeking any action based on the topics that we discuss here today. And also, we'll be splitting the topics. We'll start with immigration matters, and then we get into some corporate work, like incorporating a business and all that stuff. And then we'll also discuss some aspects of litigation, and then I'll open up Q&As on all the other topics that you want to discuss. But at the end of each topic, I'll give you some time to ask any questions. You could also type your questions in the chat box. In that way, it's easy. And then based on the question that you ask, I can discuss that in more depth.
That's good. Yeah, that's clear.
So today we'll discuss about, first we'll start with the immigration updates. I know there are a lot of individuals who missed the green card bus due to the retrogression of visa numbers. So I'm sure they have a lot of questions regarding the visa numbers, allocation, and all that stuff. We'll discuss about it. And then we'll discuss about the things that those people who just received the green cards may want to ask about, right? Whether how long they want to stay with the employer, when can they go on their own, whether they start a company, how do they do that, and all that stuff. After that, we'll discuss a few things that you need to keep in mind while starting any new business, whether it's an IT consulting firm or any other business. We'll discuss about the states where you need to incorporate, what are the choice of structures that you need to do, and then whatever are the things that like checklist before starting any IT consulting firm. And then we'll also discuss about the non-compete non-association clauses, because most of the people who would be joining different clients and all, they'll be encountering these issues. So we'll go through those issues too. Let's start with the October visa bulletin. I know the October visa bulletin has come up with some lot of unwelcome news for too many in the form of significant retrogression in several employment-based categories, both EB2 and EB3. But please note that the visa numbers allocation will reset as of October 1st. So as long as we have less number of applications that are currently pending with USCIS, then the dates would continue to move forward in the near future. Okay, so with this regard, I just want to give you a little bit background about like how these visa numbers are allocated and why I feel that the dates could again move forward, maybe in the month of Jan or February of next year. Okay, so typically, as you all know, Department of State issues visas like 140,000 visas are typically granted by the Congress, right, for employment-based category. Okay. And whenever there is, of course, like there are similar number of like 140,000 visas available for the family-based category too. But if the number of visas don't in family-based category do not get used up, then they will flow, they will be transferred to the employment-based category. Okay. And because of the pandemic situation, the consulates were closed, so there not enough number of family-based visas were issued. Hence, the number of a lot of visas from family-based got transferred to the employment-based. That's why instead of 140,000, USCIS had approximately 270,000 visas that were available that were for the employment-based category. Right? And this all happened only because they could not use up the visa numbers in the family-based category. Okay, so somebody asked me a question. If a person filed in EB3 in May 2015 priority date, do you recommend filing an EB2 now? Assumption is that EB2 will move faster than EB3. What's your recommendation? Good question. So I'll answer the question in a couple of minutes, Prasad, because so the way it works is, so family-based case, like the visa numbers are like they got transferred to employment-based. So initially they will be transferred to EB1 category. If EB1 category, if they are not able to use up all those numbers, then they flow to the EB2 category. Okay. Similarly, if EB2 category, they are not able to use the numbers, they go to the EB3 category. Okay. So EB2 typically is always the best option, but here there is another thing that comes into play. So each country has a maximum number of 7% allowed. Like so if you look at all the combination of all the visas available, right? Family-based, employment-based, investor, or everything, right? So you should multiply that by 0.07, and that is the maximum number of visas available for that particular country. But if Department of State is not able to use up all those numbers, then they can actually transfer the numbers without the 7% limit. Okay, but they can do it only on a quarterly basis, right? So that's when, like typically you see the EB3 moving in a different, moving faster sometimes, but usually EB2 is the best option. So to answer your question, EB3, if a person filed EB3 in May 2015 prior date, do you recommend filing EB2 now? Good. So if you're starting your PERM application, then do the PERM application in EB2 category. That way you'll be able to file your I-140 under EB2 or EB3, whichever moves faster at that point of time. But since I see that you already have an approved I-140 under EB3 category, right? So would you be, I don't know if you're eligible for EB2. If you're eligible for EB2, then yes, definitely I recommend having another I-140 under EB2 category. So Prasad, I see that you are eligible for EB2. Then I recommend having at least when you actually at the time of filing the PERM itself, I recommend doing it under EB2. In that way, you'll have the option of filing I-140 under both EB2 or EB3. Still mention per se case in H1B stamping, even when change charges are dropped off by dependent. An employee recently got a job in Tennessee where I moved to the state and got cheated by landlord. Landlord claims some charges on me, which were not proven in court, and judge dismissed the case, found I'm not guilty. Good. So first of all, I don't think this is a criminal charge. It's not a criminal charge that you've been charged with. So you should be fine.
Okay, thank you. So I don't know if it's a criminal charge or not, because there was no help for me at that time, because initially I'm a student and I stepped in. But when I checked with the state public lawyer, he said, like, since your charge is dismissed, you're not found guilty, so you're good to go.
Yeah, you're good to go. But again, I just make sure since you're not found guilty, you should be fine. But again, the other thing is, first of all, I don't even think that this is a criminal charge.
But
Maybe
he,
you did
but
do you know what was the
the-
charges that he filed?
he charged some booking something.
Booking?
Yeah, booking. I think I went to some place and they took my stamp or something.
Fine. Anyways, see, Nala prosecute is different, and getting the case dismissed is different. Okay, Nala prosecute means that they not prosecute it any further.
Okay, but
Okay.
what about the booking and all? Like, I don't know about that booking and all because he put it.
Okay, here in this case, was he like were you going after the okay? Was it the state that was prosecuting the case, or was it the landlord?
Landlord.
If it's a landlord, then it's not a criminal case.
Okay.
Okay,
But
because criminal cases are typically filed only by the state.
oh, okay.
Okay, so if it's a landlord, then I'm not even worried about it.
Okay, but what about if the landlord charge some booking and all, like miscellaneous? Like I didn't hurt him anything, but he charged some. I hurt him something, and judge ordered some booking kind of something which I'm not aware of anything. Like I went
Okay.
to one of the place and they took my stamp and all, and even I talked to the police officer. What is this booking and all? He said like it's just for the records. You don't need to worry about it.
No, when you say booking, they typically the booking happens if they are trying to if they are trying to arrest you. Okay,
They didn't arrest me.
They not arrest you, right?
No.
Then why did they do the booking?
Okay.
Okay.
No.
Anyway, send me the information. I just texted you my email address.
Okay.
Okay. Again, this depends upon state to state. So let me at least look at the document.
Okay, perfect. Thank you. I'll reach out to you. Thank you.
Yeah. We discuss generally about the visa number allocation. So my feeling is that since the number of the consulate are still not operating at their full capacity, I'm hoping that we'll still continue to have more number of visas overflowing from family base to employment base. So there is a good chance that the dates could again continue to move forward, but not at the same pace as they did before. Does anyone have any questions regarding the visa numbers or the bulletin?
What's your prediction though for 2026?
Prediction? Okay, see, I'll tell you one thing. So I'm hoping that by maybe as long as, see, here it's a little tough to predict because USCIS does not actually disclose the number of I-140s that are currently pending with them. And also it is hard to predict how many, because a lot of people have like multiple I-140s filed on their behalf, right? But my gut feeling says that since most of the people who have priority dates until like 2014, most of them received their green cards already, right? So I'm hoping that by next year, by early next year, the dates should move back to 2014, November or December.
Any forward movement after that? Q2?
There could be, because see, I'm assuming that because there will be again 140,000 visas available in employment-based category, right? Similarly, there would be visa numbers that are available in family-based, and even now the consulates are now not open completely, right? There are a lot of family-based cases that have been pending for years now, for almost since 2020. Like when those cases for which the M130 got approved and consular notification has been issued, the visa officer has the NVC has not scheduled the visa appointments. So I'm assuming that the more number, like there will still be some number of family-based visa numbers that will be transferred to the employment-based. The dates are not going to go as fast, but definitely I don't see. I'm assuming that again, like, don't hold me to this one. I cannot say anything for concretely, but I'm assuming that it will actually reach this the December 2014, whatever we have, in maybe by February or March of next year.
So reaching 2015 may not be possible in the current new year.
We never know. I'm not saying like it won't be possible. It all depends upon like how many number of applicants are already petitions are already pending with USCIS.
It's $1 million question, the duplicates.
Yeah. But again, whatever I'm telling you is just based on my gut feeling. Please don't hold me to that one. I cannot guess how the bulletin would move every month, or it's hard to predict the bulletin 2 months from now, right? Forget about like so.
Understood. And I don't think they'll be running at the same pace what they had. They had a good year this year, probably
Well,
best.
see, this is what I feel. Okay, because remember, like in the last few months, USCIS had to use up all the numbers, so they had to work on a lot more petitions in the last minute and all. So I'm assuming that this year they will be the day, like it won't be the same way, but I think it should at least reach the November or December 2014 by February or March of next year.
Okay, thanks.
Yeah. And a lot of people ask us whether they can extend their EAD advance payroll while the dates are retrogressed. Right. So I'm going to discuss about some of the questions that typically we receive from those individuals whose dates are retrogressed. Right. So one of the questions that typically ask is whether they can extend their EAD advance payroll when the dates are retrogressed. So the answer is that as long as you have a pending 485 application, you can always extend your EAD advance payroll. And if your prior date is not current, then typically you receive EAD advance payroll for 2 years as against 1 year. Okay. So when it comes to extension of EAD advance payroll, the fact that there is retrogression does not affect you negatively, but it may affect you only positively. Okay. So another bigger question a lot of people ask us is regarding aging out children. So is there anyone in this group who have children who could age out? Or does anyone have aging out issues for any of the children? Okay, so Vijaya has that one. So let's get to that. Okay, so typically in order for the children to be eligible to receive green card, right, as a dependent from their parents, they had to be below 21 years of old. Okay, if someone crosses 21, they will not be eligible to receive green cards as a dependent. But there is an exception to this. So there is an act called CSPA, Child Status Protection Act. Okay, so based on that act, they look at the child's age minus the number of days the underlying petition, whether it's I-140 or I-130 has been pending with USCIS. When you subtract this age, subtract these number of days from their age, and as long as the final action date became current as of that particular date, and if it happens to be below the age of 21, then they will still be eligible to get the green card. So I know it's confusing, but I'll explain a little bit. So assume that somebody filed for their green card, right? And the final action date became current on a particular date, all right? Assume that that date is August 2022, right? So what you need to do is you need to subtract. So you look at the child's age on that day when the final action date became current. Okay, you will subtract the number of days the I-140 or the I-130 petition, whichever forms the basis for filing the I-485. You will subtract the number of days that petition has been pending with USCIS. Okay, once you subtract those number of days, if the child's age is below 21, then you are fine. So Prasad, is it clear, or if you want me to give, like, if you want to give some numbers, then I can explain you better.
Let's say the candidate age is, let's say, 19 years right now.
Okay.
And the I-140 date is, let's say, 2015, August. And the candidate is August 2009. 19 years by August. So now.
Okay, let me ask you first question. Did your final action date ever become current after filing 485?
No.
No. Okay. So that is the first question that we need to look at. So if your final action date became current at any point of time, then the age is logged at that point of time. So in this case, your age, the child's age is not logged yet. Okay. How long was your, like, how many days was your I-140 pending with USCIS?
So that's like 7 years.
No. Not 7 years. Okay. So the I-140 process itself.
Oh, okay.
When did you apply for your I-140?
So it's
Do you
it's
have
a
the
year, almost in a year. Yeah, almost
It
in a
took
year.
almost a year to get the
Yeah.
I-140 approval.
Yeah,
Not the perm, just the I-140.
yeah. That's
Okay.
right.
So what you will do is assume that your final action date becomes current in 2023.
Okay.
Right? So on that day, you will look at your child's age. Okay.
Okay.
And then you will subtract 1 year from that
Okay.
because your I-140 was pending for 1 year.
Okay.
Right? And
Right.
if that age is less than 21, then you're fine.
Okay.
Does it
If
make
not-
sense?
Yeah, it does. But if not,
If not, the child would age out.
and then they got to apply for a fresh H1 and all that, because right
Yes,
now,
they have to do that, and then you can file the I-130 for them because although they are over 21, as long as they are not married, you can still sponsor their green card and under family-based category.
okay, that's a different bucket. Yeah, okay.
Yeah,
Just want to hear out your thought here. Like, I mean, in his case, previous example, he already converted child to F1, right?
it does not matter.
So he can still file the 485 if the dates go into
Yeah.
the 15.
Yeah. Yeah.
Okay.
Oh, there's another thing too. So at the time of filing 485, the child has to be less than 21, not the CSP age. The regular age also has to be less than 21.
So, I mean, if the family is filing 485 together, though the child is on F1, you are suggesting they can go with the 485, right? Altogether.
Yeah. As long as he is less than 21, he can still file for his I-485 application.
And then if the final action date of 2015, whatever in that example, right? If it doesn't
Mhm.
reach before he turns 21, what will
Well,
be his time?
Then you will subtract the number of days that the I-140 was pending.
No, I'm just asking, like, if 2015 is never reached, like, as a final action date in the next 2 years, because his child is aging out in 2 years, what will happen? The filing
what-
date.
So apart from the 2 years, he also has the number 1 plus year, extra 1 year, right? Because the I-140 was pending for 1 year.
Correct.
Right? So within that 3-year period, right? So that means before, as long as his final action date is reached before the child hits 22 years old age, he should be fine.
All right, sounds good.
So instead of 21, it's just you 21 plus the number of days the I-140 was pending with USCIS. So that is one of the reasons why I was recommending a lot of people to file their I-140 under regular processing if they are filing 485s based on the dates of filing and not dates of final action.
A lot of people have that question, right? If once the change of status, right, especially being in US and the child's education, it's
That
very
is
critical.
fine. Even if they are in F1, there is no restriction. As long as they are in some non-immigrant visa, you could file for their I-485 application.
And
Okay.
one more question: if they are not filing 485, and if the child is not converted to F1, what is the right time? Like before 21, just before 21, or 6 months before 21, or what is the right cutoff?
I recommend 9 months before they turn 21.
Okay, all right, thanks.
Okay. Yeah, that is the best thing to do. In that way, because we don't want to be in a situation where for some reason, because sometimes what happens is there could be an issue with the school where they might have terminated the CVs, anything could go wrong, right? So we want to make sure that they receive their F1 change of status from H4 to F1 before their H4 identity expires. In that way, they don't have to leave the country. Okay, because they may have a hard time getting F1 visa stamping directly because they could be considered as a potential immigrant since their parents and everybody is in the US. So I always recommend people to file it at least 9 months to 1 year before their H4 expires.
And in this case, just filing is enough, right? Not necessarily the approval, which is taking a longer time.
Yeah. As long as you file and then you get the approval before the H4 and N84 expire, then you're perfect. There's no issue. Even if something were to go wrong at that point of time, then you'll just refile before the H4 and N84 expires. That way you get an extra chance.
Yeah, but then approval, sometimes it is getting into query, and
Yeah,
especially.
that is fine. So once
Yeah.
you file it, you can stay in the country, and then you can also continue going to school.
Actually, I am with employer currently A and in AB3. So if
Mhm.
I go with employer B as a future employee, that would help.
Mhm.
Would that help? Like my priority date is 2014 September.
2014 September.
Yep.
So what is your education qualification?
Actually, masters.
Oh, you have masters. Okay, then you could be eligible for. Then why don't you do your like you have the option of either doing it through employer B or your employer A can also file another form for you, right?
Nowadays, I'm not sure, but they might. But approvals and all those things, right? We would take like more than 6 months for the getting the approval itself.
Okay. Because the reason why I'm asking you to do this is because with the future employer, so if you're trying to file your form and I-140, right, then they might have issues unless you are planning to move to the new employer B, they may have issues showing your ability to pay.
Okay.
Right. So again, you have the option. Like if this new employer B is a big company and they can support you financially, then there is no issue. Okay.
Thank you. Yeah. Thank
Good.
you.
Yeah.
Family member visa, whether it's let's say a family member is in green card, they need to sponsor a brother or sister.
Mhm.
What is the typical time it's taking?
Well, that is taking. Okay. So this is another question. Good question that you asked. So US citizens can sponsor their siblings apart from sponsoring their parents and children. They can also sponsor their siblings. Okay. So when you're sponsoring sibling, the process takes approximately 10, 15 years, 12 to 15 years. Okay. But here you have to be really careful because if the person has any nephews or niece, right, who could age out, right, in the 15 years, then they should be very careful because once you file for their green card, then they may have issues getting their F1 visa. Okay. And now they're at a disadvantage because they might age out. That's if they age out, then they may have lose their chance of coming here on F1 visa also.
Got it. And then
Right.
it's
So
only
typically,
citizens.
yeah.
It's only citizens who can do it, or not the green card holder, right?
No, not the green card holders.
Yeah.
Not the green card holders. Yeah, citizens also, I recommend that they do it only by looking at the ages of their nephew or niece.
Got it. Thank
Right.
you.
If they are below 5, then yes, you could try that. But if they are like 8 or 9 or anything more than that, I would not recommend doing that.
Understood.
Yeah, because ultimately they might lose their chance of coming here on F1 visa. Okay, good. So let's get to Prasad's question. I think we answered. Sridhar, I-140 is approved a year ago. Employer did not give I-140 original. I have a Xerox copy. If I change employer, can be used for porting? Yes, you can use it. There's no issue with that. Even if you don't have the duplicate copy also, there are ways you can work around to be able to port your priority date. Okay. So in your case, you don't have to worry about anything, Sridhar.
Understood. Okay. Thank you.
So next, Satish, can we talk about opening an IT firm? Which state to incorporate? LLC, corporation? Good. I will get to your questions in a couple of minutes, Satish. Let me take care of Madhu's because I'll complete the immigration thing and then I'll get to the corporate matters. If you get EAD from employer 1 and then we are applying to join employer 2 with AP and I-145 is still processing, what are all do we have to wait certain time to change employer is? What are the pros and cons? Good. Okay. So when you're applying, when you're applying for employment-based green card, right? So the employer should have the intent to hire you for that particular position at the time of filing perm, at the time of filing I-140, at the time of filing 485, right? And the employee also should have the intent to work in that position at these stages. So if you are employed with the company who has sponsored a green card at the time of filing perm, I-140, 485, and 180 days afterward, then you don't have to worry about anything. You can just move on to a different employer. using AC-21. Okay, as long as you're working within the same or similar occupation. So if you're working as a software developer, you could be working as a Java developer, systems analyst, whatever. Like as long as it's in the similar field, you should be fine. But a lot of people, what they're trying to do is, so they are not, if you're not employed with the GC sponsoring employer at the time of filing 485, then I highly recommend that you go back and join the employer once you get your green card. Okay. If not, you might encounter issues at the time of filing for your citizenship application, because the officer might think that it was a fraudulent GC application since you did not intend to actually work for that employer at the time of filing 485. So does it answer your questions, Madhu?
Kind of, Andy.
Do you have any further questions on that one?
I think I'm okay.
Okay. Harinath was asking me if there is any way that we can find out whether visa number has been assigned to my case or not. Unfortunately, there is no way. And most of the, there is no way to know whether a visa number has been assigned. So Mohan, how do we expedite EAD? Espedi, he's asking me how to expedite I-131 advance payroll. Well, in case if there is a family emergency or so, then you could be eligible for an emergency advance payroll, which is typically valid for 30 days, but that is given in very limited circumstances. Other than that, there is no other way to expedite your I-131 application. Okay, so I'm going to take 2 more questions on immigration and then we'll shift to corporate and litigation matters. Mine June 2014 downgraded to EB3, got EAD and applied for interfiling, and now dates went back. What are the options to go to the other company? What are the options to go to another? I guess you wanted to move to a different employer, right, Mohan?
Yes.
Yeah. So as long as it's been 120 days since the date you did the interfiling, you are free to move on.
Thank you.
Okay. Yeah, no problem. Person is on H4EAD, spouse of H1B visa holder. Can they start business, LLC, continue to work as well? Good. So if you're on H4EAD, there is no restriction. Okay. You could start a business. You could be doing any kind of job. As long as it's a legal job, you should be fine. Okay. You can start a business. You can start LLC, corporation. You could be eligible for S Corp tax benefits also. And the other thing is, a lot of people think that if you are on H4 EAD, then you will not be eligible for S Corp tax benefits because you are not a resident. Okay, the definition of resident for tax purposes is different from immigration definition under immigration law. Okay, because you could be meeting the substantial presence test, which will make you eligible for S Corp tax benefit. So, to answer your question, yes, you're eligible for LLC to start a business on LLC, and you could also be eligible for S Corp tax benefit. Now let's move on to the corporate side. I know some Chendo and all, like you have different questions, so maybe you could email me. I'll answer your questions by email.
Some light on AB5. Do you like anything you can share? AB5 right now, this 800K.
It's 500. Can we do like, I would like to do it as, because that's like a completely separate thing, right?
Sure.
If you could
Sure.
email me, then I'll definitely help you with that.
Thank you.
Okay, because I want to discuss more about the corporate and litigation matters, because since we already advertised regarding the same.
Gotcha. Thank you.
Okay, but I can definitely help you on the EB5. If you could just shoot me an email at, I think, somebody sent my email address. So you could just shoot me an email and I'll answer any questions that you may have. Okay, so various things to keep in mind while starting an IT consulting firm. Okay, first of all, a lot of people ask me, hey, whether I need to incorporate my business in Delaware, right? So assume that there is somebody who is living in Washington and they want to start an IT company. Should they incorporate in Washington or some other state? Right? This is the first question that I receive. And most of the people, for some reason, they think that incorporating in Delaware is the best option. No, that is not true. Okay. Delaware is a good option if you have a lot of shareholders and all. And for example, if a company wants to go on IPO, right? For those companies, yes, Delaware is a good option. Because for a typical IT company, if you incorporate in Delaware, right, and you're currently living in Seattle, Washington, Seattle, right? So here are the issues that you will face. Number one, you have to abide by the regulations in Delaware. Number two, since your headquarters is in Washington, you have to register in Washington as a foreign corporation. You have to file taxes, everything there also. Okay. Next thing. So if somebody were to sue you, they can sue you either in Delaware or Washington, right? So if they sue you in Delaware, then you're out of luck because you have to hire another attorney in Delaware and then deal with it. If it's in Washington, it will be much easier for you. And also, Delaware has this weird way of taxing companies. They have these something called a franchise tax. So if you have a large number of shares, right, then you may be incurring a franchise tax also. So Delaware is not a good option for a typical startup IT company. Next, a lot of people ask me about the company structure, whether they should go with an LLC, C Corp, S Corp, whatever, right? So I want to make one thing clear, okay? S Corp is not an entity, okay? S Corp is just a tax selection, okay? So you could get the benefits of S Corp by either going with an LLC or a corporation. Does anyone have questions regarding S Corp, LLC, and corporation? Who asked me regarding this one? Give me 1 second.
What is the difference between LLC and Corp here?
Good. LLC is a limited liability corporation. Okay. Corporation is corporation. I'll tell you the advantages and disadvantages with both of these. All right. LLC is okay. Corporation is much more structured. Okay. Corporation is much more structured, and LLC is little more informal. Okay. So for a corporation, there is you need to have like board meetings and all that stuff. LLC, it's little more, it is not as much structured, so you don't have to maintain too many formalities for LLC. Okay, but if you are trying to, like for example, okay, so if I'm a vendor, I would prefer to work with a corporation than an LLC. Okay, because corporations, they have board meetings, it's more structured than an LLC. Okay, LLC is a good option if you have any real estate involved. The other thing is you are getting all the benefits that you are receiving under LLC. So if you typically what people do is they'll go with an LLC and then do S Corp tax selection. The same thing you can obtain with a corporation also. And also the other thing is it's easy to transfer shares and all that stuff when you're doing it as a corporation. So for a typical IT firm, I would always recommend a corporation and not an LLC. But again, you can always change from LLC to corporation at a later point of time. So whatever the benefits that you typically receive in an LLC, right? You will get all those benefits with a corporation when it comes to an IT consulting firm. But again, if this firm has any real estate, if you're trying to own any real estate and all that stuff, then I recommend LLC. Okay, unless you intend to own real estate through this company, I recommend corporation. Okay, next thing, how do you incorporate your business? Okay, it's pretty simple. Okay, all you got to do is go on to the state corporate website, state corporate commission website. Okay, and then you'll be able to register your business. Once you register the business, then you have to go to the IRS website and request for an EIN number, employer identification number. Once you have the incorporation documents and the EIN number, then you'll be able to open a bank account. You also need to apply for necessary state and local county licenses. Assume that you form a corporation, right, with your friends, right? The first thing that you do is you will be transferring the shares to all the partners, right? And then you will have a board meeting during which you transfer the shares. And then you will have what is called bylaws, right? The bylaws will be like a constitution for the company, right? You will discuss, hey, what is going to happen to the shares? Like if somebody passes away, how you going to transfer the shares? What are the obligations? Everything you will document in the bylaws. Similarly, if it's an LLC, you have an operating agreement. Okay, it is whenever you have a partner, I highly recommend you have an operating agreement or bylaws. Okay, if there is any conflict between the partners, the first document that you'll be looking at is this one only. Either if you have a bylaws, then you look at the bylaws. If you have operating agreement, then you look at the operating agreement. Okay, so once you start, okay, so assume that now you incorporate your business, ABC Corp, right? First thing is you incorporate the business. Second thing, you get your EAN number. Third thing, you open your bank account. Okay, and then you look to see if the fourth, you will look to see if there are any county licenses that are required, right? So now you have all these four things, right? So initially, yes, you may not have any projects, you may not have any employees, you may not have anything, right? So there are a few sets of agreements that you need to have in place. In that way, you can start doing some business. Okay, one of them is a referral fee agreement, right? So whenever you are referring a candidate to another company, because that's how you need to start, right? Unless you are a well-established person, you would start it through reference, right? So you'll be referring a candidate to a project, right? They need to have what is called a referral fee agreement, right? So you'll be receiving certain amount of fee for referring this candidate to that particular client or another vendor, right? The second thing that you need to have is maybe an exclusivity agreement, right? So whenever you're submitting the resume for a particular candidate to a client, right? You want the candidate to sign an agreement saying that, hey, I'm authorizing you to submit my resume to this particular client, and that if I will not be joining the client directly without your approval and all that stuff. So you need to have that agreement also in place before you submit somebody's resume to the client or a vendor, right? The next one is a subcontracting agreement. So if you are trying to subcontract with somebody, right, then you need to have a subcontracting agreement. And the other thing, the last thing is an employment agreement or employee handbook if you want to hire them as your W-2 employee. So you need to have all these in place once you start your IT company. Does anyone have any questions regarding this? Okay, so somebody's asking me, is Virginia or Maryland better to incorporate for federal projects, or state of corporation doesn't matter, or federal projects? Good. So typically the state of corporate, they look at the headquarters of the company, right? So for example, if you are in DC, then only I think most of the DC projects are allocated to the companies that have their principal place of business in DC, right? So it's more than state of incorporation, they are looking at the principal place of business. That is wherever your company is headquartered. Good. So does anyone have any questions regarding incorporating a business, or like starting, like what any other things that you may have regarding, like you can ask me any questions that you have regarding starting an IT consulting firm now. Now let's get into the non-compete, non-solicitation clauses, okay? Because these are one of the most important restrictive clauses in any agreement. Non-compete clauses typically restrict an employee or a contractor's ability to work for a competitor or a client directly, right? So you have a non-compete clause in your agreement saying that, hey, you cannot directly work for this vendor, this client, and all that stuff. Okay, so a lot of people, what they ask me is, hey, are these non-compete clauses really enforceable? Okay, so the answer is it depends on the state, right? Some of the states, non-compete clauses with the employees are not enforceable. In some states they are enforceable. For example, in Virginia, okay, the non-compete clauses are enforceable as long as they are reasonable. Okay, whereas in certain states like California, Oklahoma, North Dakota, non-compete agreements, non-compete clauses are not enforceable. Further, in the recent past, some of these states, like especially like DC, right? DC is required. DC requires all employment agreements from the year 2020. I don't remember the exact month, but somewhere in the month of 2020, they made some changes which requires that no employer operating in the District of Columbia may request an employee to sign a non-compete clause, because most of these people are working on federal projects, and whenever there is a change in, like, because the vendors for these federal projects change, and then they don't want these non-compete clauses to affect the subcontractors' ability to work to continue working in the federal projects. So as I mentioned, right, these non-compete clauses are only enforceable if they are reasonable. Okay, when I say reasonable, they should be reasonable to protect the legitimate business interest of the employer. Okay, it should be limited in period, right? And then also in territory. So if there's a non-compete clause that says that, hey, you cannot work for our vendors, our clients, and without clearly stating who those vendors are or who those clients are, sometimes they say that you cannot work for any of the vendors. For example, assume that you have a non-compete agreement with a company that does implement all the SAP projects throughout the country, right? And if they say that, hey, if they have an agreement with an employee saying that you cannot be working for any of our clients, right, then it won't be valid, because here in this case, they have all the clients that the beneficiary could work for would be their clients, right? So it is too restrictive on the employee. And this does not protect any legitimate business interest of the employer. Okay, the same thing if the agreement says that, hey, currently you're hired to implement SAP project for the District of Columbia, right? And if they say that one, and that you cannot work for District of Columbia directly and provide the services as an SAP consultant, then it could be valid. No, sorry, instead of DC, I would say Virginia or something else. The other thing is, a lot of people ask me, we are buying a IT company, okay? And this IT company has non-compete agreements with all these employees. So now that I'm buying this company, will all those non-compete agreements flow with the purchase? Right? So assume that you are currently employed by ABC Corp, and some other new company came and bought ABC Corp, right? So the new company is, maybe you could just say as XYZ, right? So you have the non-compete agreement with ABC Corp, but now XYZ became the owner of the company, right? So ABC Corp cannot assign these non-compete agreements, compete clauses to XYZ unless you specifically agree to it. So in order for non-compete clauses to be assigned to the new purchaser, the employee has to clearly, like when you're having the non-compete agreement, you need to clearly authorize the same thing. So what are the benefits of S Corp? Good. So S Corp is a flow-through taxation. So when you're, okay, I'll give you an example between the difference between C Corp and S Corp, right? Assume that you have a C Corp, right? And then the C Corp is making $100. So what happens is, first the C Corp has to pay taxes on that $100. So assume that the corporate tax is 25%, right? So now C Corp, after paying the $25, it has only $75. Now that $75, you can take it as a dividend, right? And then you will pay taxes on that $75. So ultimately you'll probably get like $60 or so. Whereas if it's an S Corp, then you don't have to, the company does not pay any taxes by itself. So you will receive the whole thing as a K1 for yourself. So you'll be paying the taxes directly. So instead of paying taxes twice, right? One at the corporate level and one at the individual level. So using S Corp, you'll be paying taxes only once. So in that way, you save a lot on taxes. But again, if you have an S Corp, then you cannot be taking everything as dividends, right? On K1. So you have to be employed with that. Like you have to run your payroll also through that company. Whereas if you have a corporation, you don't have to run your payroll through that company. So if you do not intend to take any money from the company, right? and then just keep on reinvesting, then maybe corporation is also a good option. Okay, so by choosing S corp, you'll be paying taxes on everything that the company is making immediately. During that year itself, you'll have to pay all the taxes. Whereas if you have a corporation, then the corporation has to just pay the corporate taxes, and then unless they are issuing dividends for that particular year, you don't have to pay any taxes on that one. So, Ceci, to answer your question, using S corp, you get the tax benefit because you are paying tax only once and not at the corporate level. They will sell only assets of the company. Does that include the company registrations as well as EAN number? No. So when they say assets, it's not the company name or it's just whatever the company is owning and not the company itself.
Okay, thanks.
Okay. Yeah. I think Balvinderji, Boli, I think you raised your hand.
Yeah. Yeah, we have applied for green card. We have received our travel document, security number, employment authorization, and the approval was given to us in November 21. I want to know how long it will take to get our green card.
So when did you file this petition? I think you might have filed it in the month of March or February 2021.
Yes, in the month of March 21.
Okay. Well, you should be receiving it anytime. Now, you should be receiving it anytime now. You may be receiving it in the next couple of months.
Next couple of months?
Yes. Because we have seen GC approvals for cases that were filed and during the same time.
Okay.
So you may soon be, unless there's an RFE, you will be receiving your green card soon. I guess it's a family-based. Your son or daughter is a US citizen who sponsored you, right?
Yeah. My son has applied for it.
Yeah, you should be receiving it anytime.
And are there still interviews for the green card process, or they are giving to parents without interview?
Well, it's there. Most of the times there is no interview, but sometimes there are.
Okay, thank you.
Yeah.
Well, second question.
But you should be receiving it anytime soon now.
Second question is that on travel document, we are traveling to India and we'll be back in February 23. But before that, US visa expires in October 22. Will there be any impact on our re-entry into US?
No. As long as you have a valid advance payroll, there is no issue. You don't worry about the visa anymore.
Visa is not important now.
Not important. It has nothing to do because you are coming on advance payroll and not on B1, B2.
Okay. Thank you, sir.
You're welcome. Thank you, Ji. Hi, Ishwar, can we go ahead?
Yeah, thanks for giving me this opportunity.
No problem. Thank you.
Yeah. So actually, I went recently for India for stamping, and I got 3 years stamping on my visa. I mean, in passport. So while entering into the US, and because of my passport is going to expire next year, so they gave I-94 as only. Sorry.
Yeah, go ahead, please.
So my I-140 is going to expire. I mean, I-94 is expire next year, October 23rd. So because of my passport is expiring on that day. So if I get new passport, is it mandatory to get updated I-94, or I can continue without that?
No, you need to get an updated I-94. So good thing is, since you already have a visa, right? All you got to do is just go out. Once you get your new passport, go out of the country and then come back in.
Is there any office or something I can go there?
No, the office may not be. See, it has to be done actually at the port of entry. So you could travel to either Canada or Mexico.
Okay.
Yeah, you don't have to go for stamping again. You just show your new passport and then they'll issue a new I-94.
Okay, but I need to go out of the country.
Yeah.
Thank you, sir. Thanks a lot.
Yeah, no problem. Yeah. So we will conclude this session for now, and then maybe in the next session we can discuss other topics. Thank you all for joining this call, and then thank you, Washington Telugu Association, for running this call.
Thank you.
Quick question, Andy.
Sure.
Me real estate related issues deal చేస్తారండి మీ law firm?
Real estate చేయమండి. Actually, I'm a civil engineer, but we don't handle any real estate matters.
Okay, thank you.
So now that the dates for the EB2 and EB3 went back to 2012 with the October bulletin, is there any way that is there a possibility that it's gonna come back like maybe 13 or 14?
Yes, I'm assuming, like, my gut feeling says that it should come back by Feb or March of 2023.
Okay, thank you.
Sir, I have a question. Like, for the IRS tax dues, does it impact any H1 or H4 related?
IRS tax due do not, because it's a criminal offense. If you are failing to pay IRS taxes, it could be a charge considered as a criminal offense. I highly recommend that you pay any taxes that are due to IRS.
I have been established as an installment payment agreement, which they have been.
Instant payment agreement is fine.
Okay.
There's no issue.
So having as an installment agreement in place, and I was keep paying the installments, does it impact any immigration at any point in time?
No. As long as you are paying your taxes in installments and then you're not missing any installments, you should be fine. Nothing to worry.
Got you. Thank you so much, sir. Thank you.
No problem. Yeah.
One quick question. So for a new registered company, so how many employees does it have before it initiates starts the green card processing for an employee?
So green card processing or H1B? What are you speaking about? Green card processing?
Green card. Yeah. How
I recommend having at least 2 to 3 employees. That will help. But we have done. Like we had a situation where we did GC for a company that had 2 employees and I didn't encounter any issues.
Okay. And can the CEO of the company also can be filed as part for the GC through that company?
Good question. So the thing is, if the CEO is related, like who is going to, like, there should be employer-employee relationship, right? Typically for H1B, right?
Right.
When it comes to the green card, they want to make sure that the employer did conduct the recruitment properly, right? If the beneficiary is related to the employer, so here in this case, I guess, who owns the company? Is it the CEO?
The CEO owns the company. Yeah, the CEO owns the company.
CEO is owning the company, so his CEO has his H1B through the company?
Yes.
Okay, then who are the shareholders? Like, does he own more than 50%?
No.
Okay, so the CEO owns minority share,
yes.
Right? Okay,
yes.
In the company, then you have to disclose the fact that it's a closely held company and that one of the beneficiary is also a partner in that. So you have to mention that on the form application. There could be an audit, but it might get up. Like we had situations where in this case got approved, but after an audit.
Okay.
Thank you all for joining this session. I think we answered everyone's questions, right?
Yeah, we covered all of them.
Yeah. Sorry, guys. I'm actually having a sore throat today. I don't know why. So I'm hoping that I was audible.
Yeah, it was audible. It's good.
Okay.
I think we can conclude it now.
Right? Yeah. Thank you all.
Thank you.
Thank you so much, sir. Thank you.
Thank you.